1992 Constitution. 3. Whether or not the second respondent still met the Article 63 Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman-South constituency presidential election results. 4. Whether or not the declaration by the first respondent dated the 9th of December 2020 of the results of the presidential election conducted on the 7th December 2020 was in violation of Article 63 Clause 3 of the 1992 Constitution. 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. By virtue of the powers vested in this court under Rule 5, Sub-Rule 4 of CR 99 to dispose of this petition within strict timelines, the following orders are made accordingly. 1. Mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2. The witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3. The respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4. The first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021. 4b. The registrar shall ensure service of the submissions of the preliminary objections by the close of the day on Friday, the 22nd of January 2021. C. The petitioner shall file any response to the submission of the preliminary objection by noon on Monday, the 25th of January 2021. D. The registrar shall ensure service of the petitioner's response by the close of the day on Monday, the 25th of January 2021. E. Ruling on the preliminary objection will be incorporated in the judgment of the court. Timelines. The court shall sit on Tuesday, the 26th of January 2021 for hearing of this petition.
My lords, we have just heard the orders that you have made. We thought that part of the hearing this morning was in effect to enable us to make representations on the various things, but it looks like your lordships have made certain orders, and there is some degree of unclarity, at least in our minds, as regards what is referred to as a preliminary objection. Because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
Of the primary objection. The issue to be determined as preliminary objection. That has been set out as read by the President of the court.
Well, perhaps we could hear it again, because it was not...
Is whether or not the petition discloses any reasonable course of action. That's it. Please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. Because it's case management, you have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements, is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning, as of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other party. There are a number of outstanding issues which have not been discussed.
Mr. Jigata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99.
And have the notice to admit.
Yes, but my lord, it can affect the issues. In fact, your lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Chikata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements,
yes,
which are limited to.
You are going to call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses, but in any case, we have now, today, until tomorrow, in order to prepare witness statements.
Mr. Jikata, this should have been prepared already.
No. Well,
these statements should have been prepared already.
Well, that is not correct. Maybe your lordships,
Mr. Jikata, excuse me. Mr. Yene, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Chikata whether they were limiting themselves to the only 2 counsel. Mr. Chikata, I think you remember the very day, and you said you were with only Mr. Luther, and you were recorded as such. But Mr. Ayine, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's the 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
We are grateful to the court.
Please, resume your seat, please.
Lord, we are most grateful.
All rise.
All right. Let's go.
Your reaction to the ruling.
Out.
Came out of court. You all know what was scheduled for today was to be the pre-trial hearing. But before that, the petitioner's team, lawyers, had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of the interrogatories. Well, the court took cognizance of that and retired into chambers to consider the issues that we had been ordered to all file. So at the end of the day, the court came back and read the memoranda of issues. 5 issues have been set down for the trial and determination of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing of the petition in strict conformity with the CI 99. So we are all supposed to be back on the 26th of January, that is Tuesday, this coming Tuesday, for the hearing of the petition to commence in earnest. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable cause of action. Indeed, in second respondent's answer, that matter was raised by the second respondent's legal team as a matter which should be considered by the Supreme Court, and that has been set down for preliminary legal argument. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you. They were advocating for a live broadcast of the proceedings. Not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint or the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
That the call for a review of the court's decision is not to stay on proceedings. However, as an interested party, are you not concerned that in the future, when this case has traveled and the issues are brought back, that it could take all of us back to the very beginning of matters?
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
Please. It's okay. It's not working. It's okay.
Yeah, Gordon.
Yes, what is, are they going to ask?
No, I think we just go
Okay.
ahead and greet them and then.
All right. Good morning.
All right, Council, thank you very much. Give us your reaction to the court's ruling today.
Well, we are quite shocked because we are here for pre-trial, for case management, and for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you will come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel, for the second respondents think that they're not well prepared for this trial. You seem to raise objections to everything the court raises.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by lead counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as he stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us, that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something that you will be able to meet them in terms of your case? You are the ones who have brought the petition to court. And what does it mean for putting together a solid case to put across your court?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court. We wouldn't have filed the petition in the first place. all we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 26th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of the 2013 petition,
yes,
and the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial. What do you make?
Well, we are yet to, I mean,
Serve the order.
we are yet to be served the order. We are now going to look at, because it was just read to us, we need to now sit down and look at it. Did it, because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed and the court bringing it together so that we are all agreed on the issues. That didn't happen. So we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Your colleague, Dr. Ayemi, was remanded by the court for certain gestures. What response to that?
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Can we get tea version?
Yes. Baba Jamal. Yes.
Yeah. This one, you are dealing with your friend.
Yes.
Your friend.
The chief can come up.
Mr. Ene, once my boss I have a specific question. Which
What has accounted for the inability of the plaintiff?
No, it is not the inability of the petitioner to bring witnesses. All right, we had indicated, in our petition that we will be calling most likely 5 witnesses.
Yeah.
Okay. Now, we thought that at case management, at the time of case management, which is 5 days of, time, okay, a 5-day timeline granted by the court itself in the new rules. Okay, we thought that we should be in a position, okay, to plan together with the other parties on how many witnesses we are going to call. So it was not the case that we are not prepared with our witnesses. It is just the case that we are met with a situation where we are being given 1 day to prepare our witnesses and then make sure that we file the witness statements, by noon of tomorrow. So it is not about, it is about tight that are being given by, and I think that the court is being very unfortunate. When you have indicated that pursuant to CI 99, there are 5 days for case management, and all of a sudden the case management is reduced to 1 day by the court arbitrarily without any consultation with the parties, all right, then that is our lead counsel Tachuchi Kata made it very clear. They are seeking to sacrifice justice on the altar of a so-called speedy trial. Okay, and that is not fair. The fact that we spent 8 months, right, dealing with the first presidential petition does not mean that now everything we do
must be geared towards, attaining a speedy trial at the expense of fairness. Okay, and I think that is a very worrying development.
But your opponents also say that justice delayed is justice denied. Speed and justice probably go together in this instance, and the assertion is that you are delaying.
No, that means that you cannot sacrifice one for the other. Justice delayed is justice denied. That is true. However, the court itself has indicated that we have 42 days to complete this trial. It means that in the wisdom of the drafters of the rules, that is the Rules of Court Committee, 42 days are sufficient for purposes of conducting a trial in relation to a presidential election petition. Okay, you cannot now begin to truncate and deny the parties the right to be able to, for instance, file preliminary, applications that are mandated and allowed by law, just because you want a speedy trial. Okay, and to be honest with you, I was shocked at what was happening, and you all realize that the Chief Justice singled me out, that my body language was inappropriate. But that is because I was very shocked, because after 25 years of law practice, I have never seen this happen, that a court will arbitrarily announce the timelines for the parties without consultation. I had occasion to ask Mr. Akoto Ampao why he did not object to the tight deadlines. Okay? And sitting down there, it reminded me of an inscription that was on the desk of my secondary school rector in Notre Dame Secondary School. It said, "Don't confuse me with the facts. My mind is made up." Thank you very much, ladies and gentlemen.
Thank you very much. Honorable Kojo Ponkroma, who is the President's representative at the Information Ministry, will speak to us now. Yes, so how do you react to everything that has happened in court today, very briefly, sir?
I think all of us need to go back to the basics. Ordinarily, when you file your petition and the respondents file their answer, the next logical step is case management, which starts with a setting out of the issues and then a timetable which includes when witness statements are filed. On the first day when we came, our colleagues from the other side started off with an interlocutory application asking for leave to go and amend. And therefore, they started delaying the 42-day clock. That was granted. We had the opportunity to come back earlier this week, and the afternoon before we appeared in court, they filed another interlocutory application, which, as you all saw, took us, almost 2 hours or so, and the court dismissed and said, let's go back to case management, which is what we should be doing now. Every lawyer knows that by now, when you are coming to court for case management, first, your memorandum of issues, you've drafted it. Second, your witness statement, you have a draft of it. So these matters become procedural. Because our colleagues are seeking to delay the process and get a media spectacle ongoing for some months, all they are doing is theatrics in the chamber, seeking to delay the time. So today, even after the court has ruled, or just before the court rules, they bring another application for review. Every lawyer knows that the law is that an application for review or an appeal does not operate as a stay of proceedings. Every lawyer knows this. So you cannot claim or pretend before the cameras that by mere virtue of the fact that you have filed an application for review, there ought to be a stay of proceedings. Because it has actually been, I think, slated for hearing tomorrow. The return date, I think, is tomorrow on it. It will be heard.
Counsel for the petitioners feel that they in fact took an exception to the argument that they are delaying the trial.
They are allowed to take an exception.
What they are doing is due process.
They are allowed to take an exception. But I want to come to another issue. When the court determined in the end that witness statements should be filed on X or Y date, you can check from any other lawyer. Mr. Mahama filed his petition on the 30th of December. True or false? Nobody chose witnesses for him. He listed 5 people that he had as witnesses. That presupposes that he knows who they are, he knows what they are going to say as witnesses on his behalf. Today, when the court says that by this date, bring me the witness statement, now they say it's too short and that they are being rushed into putting together witness statements. We didn't choose their witnesses for them. From 30th of December till now is what, 20 or 21 days? And Mr. Mohammed's lawyers are saying to us that they have not drafted witness statements. They don't have a draft of it. From 30th of December, when they filed their petition and chose their own 5 witnesses, they didn't know what the witnesses were going to say. They haven't drafted it. Respondents have listed what they want to do. And we have a fair idea what it takes to contend this case. Now, if they claim that they need to go back to the interrogatories before they can agree to the issues as have been set out and prepare their witness statements, what it means is that their application for interrogatories were a fishing expedition. That what they were doing was to use it to explore what issues they can come to court with. They have been very clear to the Ghanaian public that Mr. Mahama won this election. Mr. Mahama himself at his press conference said he won the presidential election. That means what? He got 50% plus 1. You have an opportunity in court to prove that. Now Mr. Mahama abandons that one and moves on to this new thing of nobody got 50%. And when we say bring your witness statements, he says it's too early to bring his witness statements. Okay. That's ridiculous. And we are of the view that these are just efforts to delay what CI 99 sets out clearly, that there must be justice, but it must be done expeditiously. Nobody is short-circuiting the process.
You seek to emphasize the fact that your opponents are seeking to delay the process. Because what do they stand to benefit if they delay the process?
For a media spectacle so that Mr. Mahama can continue to remain very relevant in the NDC and in the public space and run again in 2024. That's all they are looking for.
So he stated that in terms of case management, it should be done among the parties involved in the case. But this time, the court has set its own rule, and they find it very ridiculous.
That is not true. You were all in court yesterday. In fact, even yesterday, when the court said that they should make their input into the first part of case management, which was the memorandum of issues, you saw them object. The court could have set, in fact, traditionally, the court will set out the issues. Now with the reviews, CI 87, etc., with the reviews, the court will invite counsel that give us your memorandum of issues and let us come up with a timetable. Let's listen to your issues and simplify. We went with 3 issues. And then the court came up with about 5 issues. 2 other issues that we were not contemplating. The court has added it as the list of issues. We are not complaining. We think we can respond to
right. Honorable,
this claim. You were all in court yesterday when they were even asked to file their memorandum of issues. You noticed that this morning they were late in the chamber. They were late in the chamber because they claimed they were now filing their memorandum of issues after they submitted their petition on the 30th of December. Now they are being asked to bring their witness statements. They are suggesting that it's too early. 21 days after they told the whole world that these are our witnesses, they have evidence to support our petition. And that is why we are saying that they are continuously trying to put impediments in the way because they want a media spectacle.
Honorable, for the millions of Ghanaians, lay persons watching us right now, who perhaps also sympathize with your side and who do not understand what the court ruling was today, how would you summarize it to them?
The court has ruled today that let us get on with the issues. Let the petitioner prove that nobody got 50% plus 1. Let the petitioner prove that the results were in contravention of Article 63 of the Constitution, as he's been claiming. I would have even preferred that they had come back to say that Mr. Mahama won this election. But you notice that they have abandoned that since they came to court. And so the court did not pick that as an issue. But what the court has said is that all the gymnastics around, let's get to the substantive issue, and has asked us to come and deal with the issues that it has set. In Chi, court in this
all right, thank you very much. And that was the Minister for Information, Mr. Kojo Ponkroma, speaking to us earlier. We also spoke with the Minister, the former Deputy Minister and Attorney General, Dr. Dominic Ayine, and both of them telling us their points of view as to what happened in court today. The Minister for, the President's representative at the Ministry of Information making a claim, a very strong claim, and I'll be joined by my colleague Edward Nyakon, Barbara, who also joined me at the moment. So as we begin to wrap up for the day's events, Barbara, let me start with you. The minister says, well, now the court has paved the way for the proceedings to hear the substantive matter to begin. What was your understanding of whatever happened in court today?
Well, I think I'm going to agree with the minister when he said that. I mean, the court says that now let's stop with all the gymnastics around. Let's get into the real matter. Let the petitioner come and prove his case. Come and prove to the court if he indeed has any case to be argued about, or to even for the court to listen to. So yes, I think it's about time we started the trial itself, and the court has said it that next week, Tuesday, 26, we sit on the petition itself.
Edward, but again, we notice, proceedings came to a halt for the jury to take a break and go into chambers to take a decision. But that was because the lawyers for the petitioner had asked for a review of the decision that was taken yesterday, dismissing their interrogatory application. Again, when the court came back, one of the issues they spoke to was the fact that, the petitioner has asked for a review does not place a stay on the proceedings, and therefore the proceedings will continue. But then again, the question is, at what point will a decision be taken on the review? And if a decision is taken and it goes to the advantage of the petitioners, will that not then put everything in reverse gear, since we would have moved forward at a point?
Well, if you listen to the arguments put forward by both sides of the coin, that is the second respondent legal team, as well as the petitioner's legal team, you realize that if you look at it from the view of the second respondent, they are claiming that it does not affect the substantive matter, because the judges are masters of their rule. And so if they are set tomorrow for that, and they are expected to also to file their memorandum of issues and witness statement today by close of day, it doesn't change the matter at stake. And so they are in a position to deal with it. And but if you look at it from the angle of the petitioners, they are also saying that, look, it will affect the statement of the memorandum of issues and witness statement they will put out there. So these are all legal issues, but let's not also forget that the court indicated that they have looked at, they should all be mindful of CR 99, which set the rules that, look here, we're not going to go the way we went 2018. We have to set a rule, and there has been a review, an amendment to all those previous issues. So pre-trial matters should not be able to stay or prevent this substantive matter from coming on board. So this is how the issues are playing out.
I'll come back to you, Edward, but the issue, and let's toss this around amongst us. You know, the lead counsel for the petitioner says it appears as though the court is sacrificing justice for expedition, justice for speed. Does he have a point? I mean, from the arguments he made and so on. You have been reporting from court for a long time. Is there a way that justice goes with speed at the same time?
Yes, definitely. I mean, it is not every time that you come to court and the processes are delayed here and then and all that. I believe the Supreme Court and the justices of the Supreme Court are well aware of the laws, and they know exactly what they are doing by asking that we fast track the process. At the end of the day, justice will be done to whoever deserves justice. And so, the petitioner, they have their own issue, but I believe that the law is working, and that is what we should allow, or we should allow to go through the whole.
All right, Edward, your take on that as well?
Yes, it goes back to the CR 99 that judges refer to, that Mr. Chikata should refer to the CR 99, which he agreed that he's aware of that. The schedule that indicate that it must be dealt with within 42 days. So in the purview of the judges, this is the way to go. And as always said, they are the masters of their own game because they set the rule and they can do whatever they want to do with the law.
We have to go now, but very finally, so court sits again exactly when? Because we had announcements about filings being done on Thursday and on Friday. Yet we
substantive matter, court sits on Tuesday, but on the review, it will be done tomorrow.
So tomorrow we are coming back to court?
Not for the substantive matter, but for the review. But for the filing of the witness statements and other processes, it should be done within by the close of this week. That is what the court has ordered.
All right. Thank you very much, Barbara Kuma, and thank you also, Edward Nyakon, my two colleagues who have been here with me in court. Earlier, we also spoke to our other colleague, Beatrice. Yvonne, our other colleague from the radio, has also been here. We will continue to bring you all the details about election petition 2020 and whatever you need to know, including what will happen tomorrow. This is where to get all the authentic information. My name is Abdulhai Mumin. We are grateful that you have been doing this with us. We will go back to our studio where our colleagues are standing by to bring you further analysis of all that has happened in court today.
Agonami, Konye Sarah Music, Aveno TV, Esia.